Ladies and gentlemen, it gives me immense pleasure to be here with you all in the land where ancient wisdom shakes hands with modern optimism. I'm talking of Sri Lanka's gracious hospitality and plural spirit echo the goals we all share, namely equity, dignity, and peace. The bonds between our countries are deeply rooted in the belief that societies grow stronger not by excluding the vulnerable but by uplifting them. The endeavor to secure justice in India for the unprivileged transcends mere legal obligation. In fact, it is and has always been a test of our collective consensus. Today, as Executive Chairman of the National Legal Service Authority in India, I am honored to share how our nation has sought to uphold human rights for those at the margins and how an ever-evolving commitment to free legal aid extending from the Supreme Court to the smallest village has transformed ideals into living realities for millions. I seek to do so by first emphasizing the Indian judiciary's role in safeguarding fundamental and human rights throughout the nation. Second, by elaborating the significance of institutional mechanisms such as National Legal Service Authority and National Human Rights Commission in aiding the vulnerable communities to assert their legal rights and freedoms. And finally, by displaying how a responsible citizenry facilitates the very spirit of our Constitution. From the earliest dawn of its civilization, India has regarded justice and access to justice not as a privilege of the powerful, but as a sacred duty of the state and society alike. Long before the vocabulary of human rights entered international discourse, India's moral and legal imagination had already embraced the principles of dignity, equality, and compassion as the foundation of good governance. I just in an instance would like to quote Kautilya's Arthashastra, written nearly 2000 years ago, emphasized that the ruler's foremost duty was the protection of his people, particularly the poor, the orphaned, and the infirm. The Dharma Shastras codified due process, equality before the law, and humane punishment. The Buddhist concept of Dhamma, propagated by Emperor Ashoka, declared, and I quote, that the state exists for the happiness of all beings. This established one of the earliest notions of a welfare governance. In these ancient precepts lies the timeless Indian conviction that justice must be lived, not merely proclaimed. Justice in India has never been transactional, it has always been transcendental, a principle of social harmony, ethical conduct, and compassion in governance. This civilizational inheritance has continued to illuminate India's moral compass throughout history. Let me just highlight how India guarantees the protection of human rights through its constitution. The 2 centuries of British colonial rule in India represented, like you suffered in Sri Lanka also, in many ways a shift in our civilization's reliance on the principles of equality and dignity. What was often described by the colonial administration as a mission to civilize was, in reality, an exercise of power that curtailed many of the rights and freedoms Indians had traditionally enjoyed. It was within this oppressive framework that India's freedom struggle ensued, and the architects of independent India's constitution, visionaries like Dr. Ambedkar and Sardar Vallabhbhai Patel, resolved to create a new legal order rooted in justice and equality for all. They knew from lived experience that freedom without dignity is hollow and liberty without access to justice is fragile. The harrowing tragedies and systemic exploitation which marked India's colonial era left indelible scars on the nation's collective memory. The drafters of our constitution drew upon these lessons when crafting foundational protections. Their commitment is evident in explicit provisions like Article 14 that talks of equality before law, Article 15 that prohibits discrimination based on religion, race, caste, sex or place of birth, Article 17 which prohibits untouchability, and Article 21 which confers the right to life and personal liberty. Subsequently, Article 39A was also added which provides equal justice and free legal aid to the citizens of India. These provisions, read together, create a constitutional architecture where justice is not a privilege for the few but a promise to all. By transforming past injustices into a constitutional mandate, the drafters of our constitution guaranteed that the cruelties and exclusions of colonial rule would never again define India's social or legal order. This is how the second role then under the constitution is played by the Indian judiciary as the vanguard of human rights. In the 75 years since independence, the Indian judiciary has functioned as the moral vanguard of this constitutional vision. Every time a person in need of such protection has approached the courts have, through creative interpretations, judicial courage, and compassion, expanded the contours of fundamental rights from a benevolent aspiration into a living guarantee, and fundamental rights under the Indian Constitution are a defined shape of human rights. For example, take Husainara Khatun's case, often called the genesis of judicial concern for India's under-trial prisoners. Here, hundreds languished in jail for years for petty offences. Through a legal aid-based public interest litigation, the Supreme Court acknowledged that poverty alone had become a de facto sentence, and it consequently declared the right to free legal representation and speedy trial as an integral part of Article 21, the same article which I was referring to, which guarantees life and liberty. The aftermath was dramatic. Thousands of under-trial prisoners were freed across India, systemic reforms were introduced, and legal aid delivery gained new urgency. Today's robust legal aid system, to which as executive chairman I am heading, owes much to the momentum created by this case alone. Thereafter, in Sukhdas case, the momentum gained further. Here, an impoverished accused faced trial and conviction without realizing he had a right to counsel, that he could engage an advocate. He had no knowledge. The Supreme Court not only set aside the conviction, calling it a violation of basic justice, but mandated that every magistrate proactively inform indigent accused of their right to state-funded representation. That if they can't afford, then state will fund and provide the free legal aid counsel to such accused. Law became not just textual, but procedural compassion in action. In Delhi domestic workers case, women workers case, the Supreme Court, aided by legal aid institutions, developed compensation frameworks and institutional support for survival of sexual violence, setting new standards for victim-centered justice. More recently, in 2017, Vrindavan Widows case showed how Supreme Court legal aid can rescue individuals from bureaucratic neglect. This case concerned the inhumane living conditions of widows in government-run shelters in a city of India. The Supreme Court Legal Service Committee and other legal aid bodies intervened in the case to advocate for the rights of these widows. Pursuant to this, in a landmark 2017 judgment, the Supreme Court issued a series of directions to the central and state governments to address the institutional apathy that had allowed bureaucratic neglect to persist. Finally, in the case of NALSA, National Legal Service Authority, you will find a very unique thing in India, that the National Legal Service Authority which I am heading, that itself becomes a petitioner before the Supreme Court. So our state legal service authority and even National Legal Service Authority, we file case in Supreme Court by our own name. So NALSA itself filed case, and one of the best examples where NALSA filed a case, NALSA versus Union of India, stands as a beacon for proactive legal aid advocacy. In a historical petition filed by NALSA itself, the Supreme Court recognized transgender persons as India's third gender, asserting their full and equal constitutional rights. This ruling extended beyond mere inclusion, sending a powerful message to every marginalized group: you are seen, you are protected, and your dignity matters. Indeed, in a recent initiative, when before I became the chairman of the National Legal Service Authority, I was chairman of the Supreme Court Legal Service Committee. And while I was there, the Supreme Court Legal Service Committee undertook a pan-India survey and identified almost 5,000 cases in which individuals convicted of murder or heinous offences were legally entitled to release on bail, or they were entitled to file their appeal in Supreme Court or any other higher court, but they were incarcerated for want of legal representation. These individuals were promptly identified. I am talking about 24 and 25 only. All of them were provided legal representation. These individuals were promptly identified and provided free legal aid, ensuring that procedural rights did not remain theoretical but translated into meaningful access to justice. These cases or instances which I have just quoted are some examples to highlight how the Indian judiciary has remained attuned to the needs of its population for decades. Another common thread connecting all these cases is that these landmark judgments came into being through significant aid and assistance provided by various legal aid authorities. That is the significance of the legal aid authorities and their functioning structure in India. It is important to acknowledge that the courts, though ever ready to protect constitutionally enshrined rights, cannot do so unless instances of violations are brought to their attention. Empowering the vulnerable to seek legal redress requires a nationwide institutional mechanism with both reach and resources. This is where the country's legal service authorities steps in. That is the gap in the system that they were and are destined to fill. This is how we try to build up the institutional mechanism of NALSA framework and global parallels. In India, the recognition of the need to have such a countrywide institutional mechanism is eventually embodied in the Legal Service Authorities Act way back in 1987. That act has created a three-tiered structure to ensure that free legal aid is available to those who need it most. At the apex, at the highest level, stands the National Legal Service Authority. Section 4 of this 1987 Act specifies that NALSA, as we call in short, National Legal Service Authority, is obligated to formulate policies, designs nationwide program, and oversee their implementation through the state legal service authorities and district legal service authorities, each chaired by sitting judges of the high courts and district courts respectively. The uniqueness of the legal service regime in India is that the Parliament, while enacting the law, itself has provided in the statute that senior most judge of the Supreme Court will be the executive chairman of the National Legal Service Authority. Senior most judge of the High Court will be the executive chairman of the State Legal Service Authority, and every district judge will be the chairman of the District Legal Service Authority. So the entire legal aid framework has been entrusted to the judiciary. That's one of the uniqueness in India, and of the I can share with you proudly that the government of India never ever has put any restriction on fund utilization. The amount we demand for allocation for the purpose of legal aid activities, for providing legal aid counsel, paralegal volunteers, and for any other activities. My difficulty throughout the year is how to spend the money. So I keep on writing to the state legal service authorities that look here, hundreds of crores of rupees I have allocated to you, please spend it for the cause for which it has been allocated, so that I can utilize the surplus funds with me. Never ever there is a lack of financial aid or financial assistance from the government side. A full-fledged budget every year is allocated to us. So that is the proactive approach of the union government also for the cause of the legal aid and for the cause of providing protection of human rights or fundamental rights or constitutional rights to the vulnerable and marginalized sections of the society. The purpose of this entire architecture is simple but vital: to ensure that no citizen is denied justice due to economic or social barriers. The statutory mandate of the 1987 Act requires that NALSA coordinate legal literacy drive, legal aid clinics, paralegal training, and alternative dispute resolution forums such as Lok Adalats across the country. We have been able to, I just to share with you, because this is something a welcome step, and I will request the Sri Lankan Legal Aid Commission and the a very vibrant bar of this Sri Lankan, that we have been able to identify mostly retired persons, retired government officials who are living in different rural areas or semi-urban areas to serve as our paralegal volunteers. We have used the word paralegal volunteers, PLVs we call, and we pay them a handsome honorarium. When I took over as chairman, the paralegal volunteers, for a day when he goes, he used to get rupees 250 minimum and up to 500. I have just 2 months back, I have revised that honorarium to minimum 600 rupees to 1000. Similarly, for a legal aid counsel, again I have 3 times I have revised the fee structure, because government is providing sufficient funds. So through this mechanism, we have been able to reach out to the streets, to every house in the village, and so much so, when there was an election dispute before me with regard to the revision of voter lists, and there were allegations that there are people who are eligible to be enrolled as voters, but nobody is approaching them, then I directed the State Legal Service Authority that your paralegal volunteers will go, get these people filled up their forms and make sure that all those who are eligible, they are enrolled as voters. So that much proactive, the working pattern and the working scope has been enlarged as far as the legal service authorities are concerned. A defining feature of legal service authorities in India is their driven approach. They do not simply wait for pleas for help to arrive at their doorsteps. They actively identify those in need, initiate proceeding themselves, and intervene before the courts, especially the Supreme Court, where systemic change is necessary. This movement from a passive model of access to an active, equity-driven model represents a historical shift. It puts the onus on the state to reach the most marginalized and not on the marginalized to find their way to the state. At this core, the legal aid movement in India stands for a simple but revolutionary idea. Idea is justice must be delivered at the doorstep where the need is greatest. Through this three-tiered structure, with the focus on free legal representation, alternative dispute resolution, legal awareness, and community engagement, India's approach ensures both reach and depth. It is a dynamic response to the country's diversity and needs. Today, India has 37 state legal service authorities, 709 district legal service authorities, and over 2,000 subdivisional legal service committees, forming one of the world's largest legal aid network. Over 50,000 paralegal volunteers are trained to assist people in villages, shelters, and prisons. Recently, during the third National Lok Adalat, which we conducted very recently, over 224 million cases have been settled, saving countless litigants' time, money, and hardship. In the past year alone, over 16 lakh people have benefited through legal services provided under this 1987 Act. NALSA's flagship programs, such as the legal services to the victims of acid attack scheme, the scheme for victims of trafficking and commercial sexual exploitation, then another scheme is Jagrati scheme for the empowerment of marginalized communities through legal literacy. All these illustrate how legal aid can function as a shield and as a means of empowerment. Our legal service authorities have been going beyond traditional methods to ensure that access to justice truly reaches every corner of our nation. Through innovative initiatives such as Tele-Law, launched in collaboration with the Union Ministry of Law and Justice, legal assistance is now being delivered directly to citizens in the most remote and rural regions of India. By using video conferencing and telephonic consultations, this initiative has overcome barriers of distance, language, and awareness, bringing the advice of a lawyer within reach of those who perhaps never know how to approach the justice delivery system. My dear friends, in Sri Lanka, probably you might not be able to appreciate the gravity of the situation which I just highlighted, the geographical barriers. Just imagine a small state like Arunachal Pradesh in the northeast. When you travel to Arunachal Pradesh, where I myself traveled for legal aid activities, from one place to another, it takes 12 to 24 hours to reach, and there are no means, and sometimes there is heavy snowfall, 24-hour snowfall, 24-hour rainfall, and there are very tough terrains that you cannot walk, you cannot reach. So just imagine a hospital where a person who is requiring emergent services, he is in trauma, and you cannot reach a trauma center. The same situation happens in the case of legal aid also. So what to do? For that to find out the solution and to meet with this challenge, that we have introduced this Tele-Law and a mobile services. So now they may or they may not. If you need a legal advice, the council, say place like Tawang, a city on the very huge height. So a lawyer sitting in Tawang, he is connected to all the nearby areas where the road can't go, person can't go, but that mobile connectivity is there. He will provide the legal services, and then he will instruct the local paralegal volunteer who is working in that village or in that area or in that hamlet, that how he will proceed to provide the legal aid to the person who need. So this is how the geographical barriers those challenges we have successfully dismantled. We have even developed mobile apps to help citizens locate the nearest legal aid office. Our legal aid offices are everywhere located. We have now entered the colleges and schools also, where we have opened the legal aid clinics in every colleges. Now we are entering into schools also, and we are making it mandatory for all these schools to have legal aid clinics. And there we provide services to file grievances or access multilingual legal resources, placing justice literally at their fingertips. India's model of free legal aid embodies the principle that justice delayed is not merely justice denied, but democracy diminished. Comparable institutional models around the world affirm the same truth, that legal aid is not a luxury but a lifeline essential for safeguarding rights and ensuring equality before law. By looking at global examples, we can see how other countries have institutionalized access to justice in ways that reinforce the same principle that guide our own legal service authorities. Now, about Sri Lanka's legal aid, Mr. Puvithran has given you the brief ideas. Two more countries I would just give as an instance. In South Africa also offers a powerful example. Its legal aid board operates through a mixed system combining public defenders, NGO and university law clinics to serve communities historically excluded by poverty or discrimination. It has been pivotal in landmark litigation that secured access to education for children in informal settlements and housing rights for those displaced by apartheid era policies, ensuring that legal aid is not merely policy but a lived reality for millions, bridging the gap between human rights standards and everyday experiences of underprivileged communities. Similar to India, Brazil's constitutionally enshrined Defensoria Publico system stands out, provides another instructive parallel for providing state-funded legal aid to women, indigenous groups, and residents of urban favelas, that small hamlets in the urban areas. But there it is confined to a very restricted part of the community, not that every person who is financially poor or who is marginalized, or that everyone is not entitled to that free legal aid. They need to expand their scope. But while I am just quoting them, these examples demonstrate that when legal aid is embedded across local and national frameworks, it can confront both immediate crisis and entrench social inequities. These initiatives reveal an undeniable truth, namely, access to legal aid substantially increases people's capacity to assert their fundamental and human rights. Now, what is the way forward? It is my firm belief that while strong institutions can deliver justice, only an engaged citizenry can sustain it. Legal aid must therefore grow simultaneously from the top down and the bottom up. The top down structure with NALSA, SALSA and DLSAs ensures a legal framework, resources and accountability. But for the system to flourish, a bottom up movement is equally vital. One where students, young lawyers and community volunteers participate actively in spreading legal awareness and delivering services. These bottom-up approaches are taking shape by harnessing the enthusiasm of our youth to further the cause of accessible justice. Over the years, I have noticed that with each successive generation, India's youth have become more attuned, empathic, and responsive to the needs of society. There is a genuine eagerness among young people to help, to give back, and to embody the values of responsible citizenship. Recognizing this, India has embedded legal aid into very fabric of its legal education. Law universities and colleges across the country operate legal aid clinics, often in collaboration with District Legal Service Authority. Through these clinics, students assist in drafting petitions, advising fellow citizens, conducting awareness camps, and organizing legal literacy drives in villages, prisons, and slum areas. In the process, they learn that law is not just a profession but a responsibility. Young advocates are also being recruited and mentored under the panel lawyer system, which I was saying that free legal aid council. These panels are developed by various courts' legal service committees, which assign them to represent indigent litigants before various courts across the length and breadth of the country. Incentives such as stipends, I was talking of the honorarium, recognition certificates, and structured mentorship programs have been made as part of the legal aid campaign, and so that they can eventually acquire the status of respectable professionals. Over 34,000 lawyers possessing more than 10 years of practice have been empaneled as panel lawyers, and several thousands more with lesser experience have also been recruited to assist them. The panel, prepared for 3 years at a time, is also reviewed and updated periodically, keeping in view the performance of these lawyers. Monitoring and monitoring committees have also been set up for close evaluation of these empaneled lawyers. India's bottom-up momentum also draws energy from civil society and the youth. Thousands of law students, volunteers during Pan-India Legal Awareness Weeks that we keep on organizing, paralegal volunteer training programs they attend, and our outreach initiatives in remote regions are also participated by them. NGOs and communities groups collaborate with District Legal Service Authority to address local issues from bonded labor to gender violence, while retired judges and senior lawyers provide mentorship. This synergy between structure and spirit, between policy and participation, represents the global future of human rights protection. It demonstrates that when citizens move in tandem but inevitable, the stories of India's legal aid movement is at its heart the story of a democracy and its consensus. It is proof that even in a vast and complex society, justice can be made real when vision is matched by institutional will. From the ancient perception of dharma to the modern architecture of Nalsa, India's journey reflects an enduring faith in human dignity and an unbroken commitment to the idea that justice must reach the last person first. Each time a prisoner regains freedom through a legal aid petition, every time a widow receives her pension after years of neglect, and every time a child in conflict with law is guided towards reform instead of retribution, the Constitution promise breathes anew. Yet, this is not a story of completion. As new challenges will emerge, such as digital exclusion, displacement, climate vulnerability, and transnational migration, our task is to innovate further, to modernize outreach, and to deepen inclusion. Justice must evolve with society, or it will risk becoming its shadow. To our friends here in Sri Lanka and across the Commonwealth, India's experience offers not a model to be imitated, but rather a vision to inspire. The belief that every person, regardless of wealth or status, is entitled to the full protection of the law is not merely Indian, it is universal. But India's experience affirms that institutionalizing that belief, making it work in practice every day for millions, is possible and imperative. Each nation must craft its own system anchored in local realities, yet inspired by a shared conviction that legal aid is the first line of defense against the erosion of human rights. When justice becomes truly accessible, when every citizen, regardless of means, can stand tall before the law, then and only then can we say that freedom has fulfilled its true purpose. Justice, after all, is not a destination, it's a journey, a collective journey of nations, institutions, and hearts. And in that journey, India stands ready not only as a participant but as a partner and pioneer, committed to ensuring that the light of human rights shines undimmed across the entire world. Before I close, I would like to express my sincere appreciation to the Bar Association of Sri Lanka and the Commonwealth Legal Education Association for inviting me to share these reflections. It is a privilege to participate in such a distinguished forum dedicated to the advancement of justice and human rights, and most particularly when a very informed elite legal community is here to share my views along with the other distinguished speakers who have also highlighted the cause of human rights and the mechanism that we can effectively introduce to ensure their protection. Thank you very much for giving this opportunity. Thank you once again.